Hello, I'm Jennifer Wheeler, an attorney with Maynard Nexsen's Employment and Labor Law Practice Group. Congress expanded protections for pregnant and postpartum workers through the passage of the Pregnant Workers Fairness Act, or PWFA. The law builds upon existing protections provided against pregnancy discrimination under Title VII of the Civil Rights Act of 1964 and access to reasonable accommodations under the Americans with Disabilities Act. The EEOC has issued proposed regulations that provide examples of possible reasonable accommodations under the PWFA, including, for example, frequent breaks or schedule changes, sitting or standing as needed, uniform modifications, remote work or telework, or job restructuring. One area of confusion for employers is when a pregnant worker who might otherwise be ineligible for leave under the Family and Medical Leave Act requests leave under the PWFA. The FMLA provides for job protection and unpaid leave for certain medical issues and to bond with a new child. However, there are many reasons an employee may not be entitled to leave under the FMLA. For example, the FMLA applies only to employers that have 50 or more employees within a 75-mile radius of the employee. The employee must also have worked at the covered employer for at least 12 months and have worked 1,250 hours during that time frame. Meanwhile, the PWFA applies to employers with only 15 employees, and an employee is eligible for accommodations immediately. Whether an accommodation request is reasonable is determined on a case-by-case basis, and an employee's request should be granted unless the employer can show the request constitutes an undue hardship. So, consider an employee hired at a small company while already pregnant or who becomes pregnant soon after being hired. The employer is now required to engage with the employee in an interactive process similar to that required by the ADA. Despite being brand new, the employee would likely be entitled to immediate accommodations like those mentioned earlier, and the employee could also be entitled to paid or unpaid leave upon giving birth less than 9 months later. If your company is confronted with a request for leave or other accommodation under the PWFA, or needs assistance in complying with the myriad of laws applicable to pregnant workers, Maynard Nexsen's Employment and Labor Law Practice Group is ready to help.